Senator Kennedy.
Thank you, Mr. Chairman. Welcome, ladies. You'll get used to the yelling.
Want to come over here?
It's happened over, Senator Tillis is keeping count. It's happened over 200 times in the last 3 days. It's not really how democracy is supposed to work. Judge, I will repeat what I said yesterday. I'm not going to ask you to give me a hint about how you might vote on the court if you're confirmed. Certainly don't want you to violate the judicial canons of ethics, and I may have to gently interrupt you a few times to kind of move you along, or move me along. Yesterday, you started to talk about Justice Harlan and his feeling about whether he should vote in a political election, and somehow we ran out of time, and I thought I'd give you an opportunity to finish that thought.
Thank you, Senator. And one of the things that we have to do as judges, as I've emphasized many times in this hearing, is maintain the independence of the federal judiciary, independence from politics, independence from political influence or public pressure or public influence. And part of that, part of the canons for federal judges, federal judiciary, is that we don't attend political rallies. We're not allowed to donate to political campaigns, support political candidates, put bumper stickers on our cars, signs in our yards. And one of the things I decided, we are allowed technically to vote, but one of the things I decided after I voted in the first election, and I read something about how the second Justice Harlan had decided not to vote in elections because he thought that reinforced the independence that he felt as a judge. And I thought about that, and I decided to follow that lead. I'm not saying my approach is right, and other judges take a different approach on that, and I fully respect that. But for me, it just felt more consistent for me with the independence of the judiciary not to vote, because I've always considered voting a sacred responsibility, and one in which I think very deeply about the policies I'm supporting and the people I'm supporting, and that seemed almost as if I were taking policy views, at least to myself, into the voting booth, and I didn't want to do that as a judge. So I decided to follow the lead of the second Justice Harlan. I'll be the first to say I'm not the second Justice Harlan. He was a great justice on the Supreme Court, and someone, of course, who I would be, if I were to be confirmed, honored to be on that court and follow in his lead.
You don't vote in political elections?
I do not vote in political elections.
Interesting. Last night you talked a little bit about your outreach efforts to attract more women and minority law clerks. Mm-hmm. Could you quickly go through that for me again? I think I was getting coffee when you were talking about that.
Senator, one of the issues in American society generally, of course, but also in the judiciary in particular, has been to advance, to overcome the discriminatory history of the country, and to help advance the cause of women and minorities in the legal profession. And one of the areas where that's revealed itself is law clerk hiring. And that's important because we get
law clerks for judges, you mean?
Yeah, law clerks for judges. We get 4 law clerks each year, and they're there for just 1 year, and then they turn over after a year. They're like a team. They turn over after the year, and you get a new team of 4 the next year. Those law clerks are among the best and brightest out of American law schools, and they often will go on to leadership positions in the Congress or in the state legislatures or in the judiciary or in the bar or in public service. And so those are important training positions for the future leaders of America. And there was disparities when I came on the bench in the number of women and minorities. So I decided to be very proactive about that. There was a problem identified. I decided to be proactive. So on the women law clerk front, I'm very proud that of my 48 law clerks, a majority of them have been women, and they're the best and brightest. and one of them was just confirmed as a federal judge on the U.S. Court of Appeals for the 11th Circuit, Britt Grant, and she was in my second class of clerks. That's important because as my mom, as I talked about my mom was a trailblazer in the law and overcame barriers to help women achieve equality in the law, and I want to do my part as well. Not just because of her, but she was an example to help achieve equality for all women, to give them a equal place at the table and future opportunities. And I think I've helped I'm just one small piece, and I don't want to overdo it, but I've tried to be proactive about it and to make a difference. So too.
What about minority outreach?
Right. So in 2009 or 2010, so after I was on the court for about 3 years, there was a hearing, I think, in the House Appropriations Committee with the two justices usually go up every year and talk about the Supreme Court budget and testify before the Appropriations Committee to get money, to explain the need for money for the Supreme Court for the following year. And Justice Thomas and Justice Breyer were there that year, and they were asked about the seeming disparity with minority law clerks in general, African-American law clerks in particular. And one of the things they said, and they were talking about Supreme Court law clerks, those law clerks for the Supreme Court justices. And one of the things they said was they hired from the lower courts, from the courts of appeals. And they pointed out that the pool in the courts of appeals had the disparities, and so they were really dependent on what the Court of Appeals did and does. I took that as a bit of a call to action to do something about it myself.
And what did you do, Judge?
I reached out initially to the Black Law Students Association at Yale Law School, emailed them and asked them if I could come talk to them. Yale Law School is a school that produces a lot of law clerks, so I thought, and it's my alma mater, I start there. And I went and spoke to them. What I did is I went and spoke to the group, and I explained to them the importance of clerking. I encouraged them to clerk. I explained the history of the disparities. Then I gave them, in essence, what I thought were tips about how to make yourself a better clerk, kind of like a coach, tips to how to be a better clerk candidate, classes to take, professors, how to deal with professors.
You think that helped?
I do think it helped. I was uncertain, frankly, sure, when I walked into the room how that would work. And it worked great in terms of the reaction I got, and also in terms of, I think, the real world results. The way I thought about it is if I make even a difference for one clerk or one student, it's worth it. Sure. And I think I did for more, and then I've kept it up year after year. I've done it also where I teach at Harvard Law School, and I'm proud of the results. I think it's made, again, a small difference, but it's one person at a time, one clerk at a time, one student at a time. And I think hopefully by talking about it in this forum, I can encourage more efforts of that nature, which are really just recruiting efforts and explanation for many of the students at law schools are first-generation professionals and don't have the networks necessarily that others do, and so
I know we could. I can tell you enjoy talking about it.
I could go for about 2 hours on that, but yes, Senator, I thank you for cutting me off.
And I'll be glad to go if the chairman will give me 2 hours, but I don't think he will.
Yeah.
I know you've read an opinion before where you agree with the conclusion, but you don't agree with the reasoning. Yeah. Have you had that experience?
I have.
Yeah, I think we all have.
Yes.
Here's why I asked that. Can you tell me what in God's name a penumbra is?
Senator, the Supreme Court, as I think you're referring to, once used that term, but it doesn't use that term anymore for figuring out what otherwise unenumerated rights are protected by the Constitution of the United States. What it refers to now is a test in the Glucksberg case, and Justice Kagan talked about this in her confirmation hearing when she was sitting in this seat. The Glucksberg case sets forth a test where unenumerated rights will be recognized if they're rooted in history and tradition. And why that matters, I think, to your point.
Can I stop you? It's deeply rooted.
Yes.
And is are those roots that are just deep? Are those roots that are deep that have been growing there a long time? Do you understand what I'm asking? Is it?
I fear I don't.
Well, yeah, that's my fault, not yours. Is it something that Americans have cherished for a long time, or can it be something that is a moray of contemporary society?
So when the court has referred to deeply rooted in history and tradition, it has looked to history. Now, how deep the history must be is there. I don't think there's a one-size-fits-all answer to that, and how much contemporary practice matters. I also don't think there's a one-size-fits-all. But the important thing is the court, and again, Justice Kagan emphasized this in her hearing, that the Glucksberg test means that the court is not simply doing what your role is, which is to figure out the best policy and to enshrine it into the law, in the Constitution in the case of the court, but rather is looking for, as best it can, objective indicia of rights that are not explicitly enumerated in the Constitution, but that are nonetheless protected. The best example, I think, is the Pierce case. Oregon passed a law saying that everyone, and this in the 1920s, saying that everyone in the state of Oregon, every student had to attend a public school and could not attend a parochial or private school. And parents who wanted to send their children to a Catholic or child to a Catholic school sued and argued that that violated the United States Constitution. It made it to the Supreme Court. The right, in essence, the claimed right was the right of parents to direct the upbringing of their children by sending them to a private or parochial school. And the Supreme Court affirmed and recognized that right under the United States Constitution, even though not.
And that is a good example, Judge, and again, I apologize for interrupting, but we're dealing here with values, are we not? That we all cherish together as Americans, like the rule of law or privacy or equal opportunity or personal responsibility. How do you determine what values all Americans cherish? How do 9 people determine what values all Americans cherish enough to read into or to discover as a result of the superior intellect of those 9 individuals is a part of the Constitution and has been there for a long time? But most of us couldn't see it except the 9 justices.
Well, I don't think that's the conception of the judicial role that the Supreme Court has articulated.
I agree, but that's the perception that some people have, and perception is important in appreciation of government.
Well, I agree with you that the values question is one that, of course, is first and foremost for Congress to figure out the policy, or the state legislatures. Judges, federal judges, the Supreme Court, we're not supposed to be, I think, consistent with your question, simply importing our own values into the Constitution. It's not just supposed to be 5 people. We're 5 people like every other American. We don't have a charter to create new rights just because we think they're best. Rather, we find them.
Excuse me again for interrupting, but I think Justice Scalia would say, and has said, that no disrespect, but that 5 people, whomever they may be, on the United States Supreme Court can establish this value, and that their sense of morality or their value system is no better or worse than picking the first 5 names in the Washington, D.C. phone book.
He did say that, and I think that is a comment that I think is shared by the justices on the Supreme Court and is reflected now in the Glucksberg test. But I recognize that it's important to explain that to people so that people don't get confused about our role. Our role is rooted in law. It's rooted in precedent. It's rooted in not our values per se, but the values reflected either in the Constitution or reflected in the legislation passed by Congress. And I realize there are gray areas in what I'm just saying, but it's very important to to
And
explain
here's
that
my
to people.
point. Excuse me again for interrupting. I will bet most Americans could agree today, and would agree, that we have a privacy right. We have search and seizure privacy is important, but we also believe now that disclosural privacy is important. Autonomy privacy is important.
Yeah.
And it's part of our Constitution. And frankly, I'm glad that it is. But how it got there matters. How it got there matters. It's not just the end result. Let me leave that for a second.
I agree with that.
And just kind of shift gears. I've just got a few minutes left. I can tell from your testimony the last 3 days or 2 days that high school those were formative years for you. You went to Georgetown Preparatory School?
I did Georgetown Prep, Jesuit High School here. It was very formative.
What was it like for you? What were you like? Were you, did you ever get in trouble? Were you more of a John Boy Walton type or a Ferris Bueller type? These ladies are old enough to understand.
I love sports, first and foremost. I think that I worked hard at school. I had a lot of friends. I've talked a lot about my friends.
Yeah.
And they've been here. So it was very formative. And when I think back on it,
You left out the trouble part. I was waiting for that.
right. So that's encompassed under the friends, I think. Yeah.
You were an athlete?
Yes, I played football and basketball. My football coach was named Jim Fagan, and he's a legendary football coach. And so over the last 8 weeks, where I've been in a slightly different situation than I'd been for the previous 53 years, in terms of where I can go freely, I've been working out on weekends at my old high school and running on the track, and ran into him out there. It was awesome to run into him. He still helps out with the football team, and he sent me a text 3 nights ago. So it's awesome.
Okay. That's all I'm going to get out of you, isn't it? I understand. All right. Let me yield back. Strike that, Mr. Chairman. I'm just in case we have to have the time. I'm going to reserve my 2 hours and 10 minutes. I'm sorry, my 2 minutes and 7 seconds. Now, see, I was going to ask the judge if not him, but any of his underage running buddies had ever tried to sneak a few beers past Jesus or something like that in high school, but I'm not going to go there.
Hey.
I want to